What makes the National Constitution Day special? How we have come so far with a constitution that was adopted back in 1949? And what are the significant changes that we need to know about? India's constitution is not merely just a legal document. It is a whole story of how a newly liberated nation imagined, visioned its future and how it gradually embarked upon it. When we talk about the conception of the idea of the constitution itself until the time it came into force and now of the present time, we get to see the visionary document that our constitution is. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and on the occasion of Constitution Day, that is the 76th Constitution Day if we take in the years since our constitution has been adopted, on this very particular day, let us understand the timeline and also the important changes, the amendments and the judgments which have shaped up our present constitution in front of us. So let us begin with talking about the Constitution Days itself, that why this particular day is significant. So when we are talking about November 26 itself, it was the day that our constitution was finally signed and it was adopted by the Constituent Assembly. Now, this adoption happened on 26th November, but the constitution came into force on 26th of January. That is why our Republic Day is celebrated on a different day. And when we are talking about the adoption itself, this day until 2015 was celebrated as National Law Day. And after 2015, to commemorate and remember Dr. B.R. Ambedkar and to mark his 125th birth anniversary, this day 26th November was declared as Constitution Day. The whole idea was to promote the constitutionalism which exists in daily governance and also encourage citizens to value rights and duties and bring the connection of the present generation and the upcoming generations with the constitution, which was laid 76 years back. Now here we will be talking about that how this constitution came into the picture, what was the making of constitution and what it looked like. Now we will be starting and understanding in detail the timeline when we talk about the adoption of Indian constitution, how it began, what was the inception point to the whole adoption itself. So when we talk about this whole concept, it was brought in by a renowned leader, that is M.N. Roy, and this happened back in 1934 where M.N. Roy proposed that there should be a constituent assembly and this constituent assembly should be Indian based. That means Britishers should not get to decide that what kind of governance that Indians should have. And this happens in the background of when there were global wars going on. World War I had ended, World War II was on inception and countries were getting freedom. The constitution making process was going all along across the globe. So in this very note, there was a major notification that came in from this side, okay, that constitution should be made from our own end. And this demand was carried forwarded by Indian National Congress. They adopted this demand for Constituent Assembly in the very next year. But it took us more than 10 years to get a Constituent Assembly of our own. The whole idea that another external force cannot decide the governance what we want. We don't want to go for British frameworks, be it of 1919, be it of 1935, the acts that had come. We wanted something that suited for ourselves and we get to decide ourselves. This happened for us in 1946 when under Cabinet Mission Plan, our Constituent Assembly was formed. Now, our Constituent Assembly was formed by a partly elected, partly nominated process, but it had representation of the provinces, of the princely states, of the minorities, as well as the diverse communities which were present. So we get to see that the Constituent Assembly that was formed, that was not only democratic and diverse, but it was deliberation oriented. That means a separate elite class was not going to make a rule book for the country, but it was based on the societal inputs by the group that had come together. Now in 1946, when we talk about this Constituent Assembly, the strength was 389, but after partition the strength reduced to 299, and then after almost 2 months happened the first session in 1946. So on 9 December 1946, the first session took place. 207 members, out of which only 9 were women, but their contribution must be acknowledged, including Hansa Mehta, Sarojini Naidu and Durga Bhai Deshmukh. So we had the first president of the Constituent Assembly as Dr. Sachindanand Sinha, but he was chosen based on the tradition because the oldest member is present till the assembly gets together and vote. And after that, the head of the constitution, the president of the Constituent Assembly, was chosen as Dr. Rajendra Prasad. Now, multiple committees were made to make sure that this constitution making process is carried out, and within that very month, an important thing was adopted, that is Objectives Resolution, that was moved by Jawaharlal Nehru. It was moved in 1946, but it was later adopted by 22nd January of 1947. Now this is where we get the core ideals from, be it justice, be it liberty, be it democracy, equality. And when we are talking about 9 December 1946, you have to remember that this was the day that marked the beginning of making of world's biggest constitution, largest constitution that we have ever seen. Now when we are talking about the whole process in this assembly worked through more than 17 plus committees. And the most important one here was the drafting committee. Now, drafting committee was headed by Dr. B.R. Ambedkar, and in his acknowledgement of the contribution, 26th November is celebrated as the Constitution Day. And this is where we get to see that how important his work was, when you will understand that this drafting committee was responsible for combining the global best practices and putting it in Indian context and presenting the world's largest constitution, while making sure bringing in reading through 7600 plus amendments which were read out of which 2200 were verified, and after that the first draft was presented in 4th November 1948. So you get to see that there was intensiveness of drafting, that in 2 years and 11 months we had 2400 amendments which were proposed, and out of which we had 2400 amendments accepted, and we had to see the humongous number of amendments which were proposed. They were drafted and finalized, where we get to see adoption of constitution on the date we are celebrating Constitution Day, that is 26th November 1949. And this happened in the miraculous timeline of 2 years 11 months itself, especially when this Constituent Assembly was working as the first government as well, managing a state of war, partition and everything that goes along. And still this constitution has been so enabled, has been so facilitating, such a living document that it still serves till date, and it has not gone obsolete, and it has held India in a great position because of how it was well placed. Now that we have had a clear idea, now let us understand the structure that came out of this whole process. So when we talk about the original constitution, which was adopted on 26 November 1949, and then it was brought into force on 26 January 1950, we had only 395 articles, 22 parts and 8 schedules. But if you look at the current structures, we have 448 articles, 25 parts and we have 12 schedules, which not only keeps us the longest written constitution, but it still holds features such as having the rigidity and the flexibility blend, also the unitary and as well as federal features, and most importantly it reflects the modern as well as traditional values which have been embedded in it. Now on this note, we will be moving towards the major amendments that have been made to the constitution and how it has ensured that the evolution of constitution with time takes place. When we are talking about major changes that have been done, we have to start with one of the biggest amendment that has been done in the constitution, and that was through the 42nd amendment of 1976. Now this happened during the time of emergency, one of the darkest time our democracy has seen, and the changes were so many that it is also, this amendment is known as the mini constitution. This was the very amendment which brought addition to the preamble, which is the 4 word of our constitution. It added 3 words, that is socialist, secular and integrity, to the preamble. It also brought in fundamental duties. Can you tell me which article talks about fundamental duties in the comment section? It also had a major focus on strengthening the central dominance. It curtailed the whole scope of judicial review, and it also worked on curtailing High Court and Supreme Court powers. The whole idea of this amendment was to prevent judicial intervention in socio-economic reforms. This was the pitch that was used to clip the wings of the other organs of power except for the executive. And this is why we had to see another major amendment, that was the 44th amendment of 1978, which basically reversed many amendments which were made in the 42nd amendment. Furthermore, to make sure that such amendments are not carried out, especially during emergency, the safeguards for emergency were raised. They cannot be raised on vague grounds. Now it was in this very amendment, because before this, emergency could be declared for external reasons, maybe there is a breakout of war or any other situation, or internal situation, and the word that was mentioned in the constitution, that was internal disturbance, and this very word was used to invoke emergency grounds here. So that is why that word was changed, the internal disturbance, which was a very vague word, and it was changed to armed rebellion in this very amendment. Furthermore, it restored the scope of judicial review. The right to property was downgraded to a legal right, and it also focused on protecting civil liberties, which were changed especially during the emergency. Then came in multiple important amendment acts such as the 61st, 86th and 101st. We have many others, but we will be talking about which have been the main highlights. For example, when we talk about the 61st, in 1989, this was when we saw the voting age from 21 was changed to 18, so as to ensure there is expansion of youth participation. Then we had the 86th Amendment Act in 2002, which not only modified the Article 21A, where right to education was brought in for especially children from age of 16 to 14, but there was also modification of Article 45 for the early childhood care. Now when we talk about Article 21A, it is from fundamental rights, but you have to see Article 45 coming from DPSPs. And there was also an addition of 51AK provision, where there is parental duty also involved. Now when we are talking about 101st Amendment Act of 2016, one of the biggest tax reforms that our country has seen, and also it ordered the federal tax structure that exists in our country. So this is where goods and services tax was introduced. Major shift was seen in indirect tax structure. It not only altered the tax structure across the country, but it also strengthened the cooperative federalism that was seen through the GST Council, and especially the reforms that have been announced this very year make it clear that how such reforms can ensure growth in our country and also facilitate the whole idea of one nation, one tax. Now moving to the other important ones. Now it was not just the constitutional amendment acts which have changed the preview of the constitution, but it have been also the landmark judgments which have contributed to the same. Now we will be moving on to the landmark judgments and taking a deeper dive to understand how they have contributed to holding up the morality of the constitution, their understanding, their significance and everything around. So starting with the first one, the Golaknath case. which was Golaknath versus State of Punjab in 1967, where the Supreme Court held that Parliament cannot amend fundamental rights, and that is why there was a conflict between Parliament as well as judiciary, and it also led to a situation of constitutional crisis. But this was the one which led to another landmark judgment, that was Kesavananda Bharati versus State of Kerala in 1973, and this was one case which ensured that constitution remains amendable, but at the same time there is no compromise to its basic structure. That means the soul of constitution remains very much intact. So it was in this particular case the basic structure doctrine had been introduced, and it had been evolving over the subsequent Supreme Court judgments. So this was said that Parliament can amend the constitution given the provisions of amendability as per Article 358, but it cannot alter the basic structure. And it also over the years has highlighted that what basic structure includes. It includes supremacy of the constitution, secularism, democracy, judicial review, separation of powers. So that means if Parliament is trying to alter this, then this will be considered unconstitutional. So the most important constitutional judgment in the history of Indian constitution, and the judgment was this one, because this made sure not just the constitution morality stays intact, but the core and soul of the constitution also stays very much in the place. After that, we have also seen multiple cases such as Maneka Gandhi versus Union of India of 1978, which helped in expanding the interpretation of Article 21, where it was clearly held that right to life does not mean just being breathing and living like animals. It includes dignity, it includes being just, fair, reasonable, and having that. So it also linked 14, 19 and 21 article into a golden triangle, which are very much important and which facilitate each other. And this was also a important point when we talk about due process like doctrine in India. Then we also saw another important judgment in 1980s, that was Minerva Mills, and then we got to see Olga Tellis of 1985. It was the Minerva Mills case that brought in the basic structure doctrine and reaffirmation to it. This was again revisited by Supreme Court. Furthermore, it also made sure that there was a struck down of unlimited amendment power that was available with the Parliament, and it also talked about the balance that needs to exist with fundamental rights and DPSPs, that they are not against each other, they need to be managed in a fair balance. When we talk about the Olga Tellis case of 1985, this was the one where SC held that right to livelihood, that means right to earn, right to do something, is equivalent to right to life. This is part of right to life, and this is where it is a fundamental right to get the basic socio-economic abilities, to have livelihood. That is also a fundamental right. So it strengthened the socio-economic rights which were available to the citizens of our country. Then we have SR Bommai case of 1994, which limited the misuse of Article 356, that is the President's rules. It made all the President decisions subject to judicial review. That means if President is taking a decision for Article 3, that means if central government is trying to use President as its agent to dismiss the government which is present in the state without any legit reason, then it is under the judicial review. And that means the state government before this, because many central governments used presidents to impose the President rule as per Article 356, where they believe that the constitutional machinery has failed, to oust the state government which was present. So it brought a lot of strength to a major basic structure pointer, that is federalism in our constitution. Then we have seen in recent time the Puttaswamy versus Union of India case, where we saw a big announcement with related to right to privacy, where right to privacy is a fundamental right and it laid the framework for the protection but also digital rights and also the proportionality test. In recent times, we have also seen the ADR versus Union of India, where the electoral bond scheme, which worked for years, was declared unconstitutional. It brought in the much required transparency, especially in political finance, and it clearly highlighted that a voter's right to information is something which is fundamental to democracy and it cannot be compromised upon. Other than that, we have also seen in 2018 the NCT Delhi case, the National Capital Territory Delhi case, where it was again held by Supreme Court that the Lieutenant Governor has to act on the aid and advice of the elected government, and the exceptions can be only for police, land and public order, especially in the case of NCT Delhi. This clearly highlighted and strengthened the principle of the representative democracies which are present in the union territories with the legislative assemblies. Now, when I am bringing these to you, the landmark judgments or the major amendments that have carried out, they tell that how the constitution has evolved over the years but still has facilitated the needs of other nation, and that is why even today the constitution and the Constitution Day has so much relevance, because no matter what the debate is, constitution remains flexible, yet it is firmly rooted, and at the same time it continues to be a flashlight which guides the India's whole transformation, be it in the social terms, be it in the economic terms itself. Now, on this note, I'll be leaving you with a practice question here. This is the practice question. You can put down the answers in the comment section. Now, the answer for yesterday's question, the correct answer here is B. That was all for today. Thank you so much.